Renee Landers is a professor of law at Suffolk University Law School in Boston, where she teaches constitutional law, administrative law, health law, and privacy law, among other academic pursuits. She also has served in a number of other impressive positions, including a term as president of the Boston Bar Association and another as chair of the American Bar Association's section of Administrative Law and Regulatory Practice. Among her many volunteer activities, Professor Landers has played and continues to play a significant role in the area of judicial ethics in her home state of Massachusetts. And perhaps most important, she happens to be a great role model for aspiring lawyers. I've known Professor Landers for a number of years and could think of no one I'd rather talk with about some of the most significant decisions issued by the United States Supreme Court in the final weeks before its summer recess, and about the current controversy over whether the justices should be bound by congressionally imposed rules of judicial conduct, as are all other federal judges. I learned a lot from the conversation, and I hope you'll enjoy it as much as I did.
So what I always say to students is that the legal education empowers them to be super involved and attentive citizens, and that they shouldn't just sort of get their degree, pass the bar, and then just go around start making money, right? Which, I know everyone needs to do, but really to stay engaged at some level on some of these issues that affect the evolution of the law and, at whatever level, state, local, federal level. So for a long time, the very first time I taught constitutional law, which was probably around the year 1990, 1991, something like that, I had assigned The Handmaid's Tale for students to read in class.
Really?
And to write a paper about.
You were ahead of your time.
And, I always hoped that it would be this kind of like deterrent message, right? This is what happens if you get too complacent about your rights. And now I sort of feel that that's, as important as it ever was to sort of get students to see that they can make a difference in these outcomes.
I'm Don Frederico, and this is Higher Callings. Today I'm with Renee Landers, professor of law at Suffolk University Law School in Boston. How are you today, Renee?
I'm fine, Don. Thank you. How are you?
I'm doing great. Thank you. I really appreciate your joining me on the podcast today. I know we talked about doing a podcast where we talked about the issue of ethics as applied to the Supreme Court. And then we decided, well, why don't we wait a little while and see what the Supreme Court does at the end of the term. So now we have a lot to talk about.
We do.
And I'm looking forward to the conversation. Before we go there, why don't you tell our listeners something about yourself? You have a rather long title, I think because you wear a few different hats at Suffolk. But why don't I just let you introduce yourself?
Sure. So I'm a professor of law at Suffolk University Law School, and I'm also the faculty director for two different programs. One is the Health and Biomedical Law concentration for JD students, and another is the Master of Science in Law Life Sciences program, which is an interdisciplinary program to help train people for careers in the life sciences industry, and people do not have to be lawyers to enroll in that program.
That's great. And maybe also, can you tell us what courses you teach at the law school?
Sure. So lately, I've settled into a routine of teaching 4 or 5 courses. The 5th one is kind of an outlier. I teach administrative law, constitutional law for first-year students, and then in alternate years, I teach health and biomedical law, and also I teach a privacy law course, which is geared primarily toward those students in the life sciences program, but the JD students can also enroll in that course. And then in the last 2 years, I've been teaching in the spring semester a seminar. We call it the Madrid seminar because the centerpiece of the course is to take spring break and go to the Suffolk University campus in Madrid and, have a series of sessions with government officials, EU officials, very distinguished practitioners and members of the bar in Spain. And then students write research papers, some comparative research paper, comparing Spanish and European law with US law in a particular area.
Where can a podcast host go to apply for that program?
Right. No, I know. I know. The first year we offered that course for law students was unfortunately 2020. So needless to say, no one went to Spain that year.
Yeah.
And then we skipped 2021 because things were not quite back to reasonable public interactions yet. But then we have gone the last 2 years. So.
It just sounds wonderful. Those are the courses you teach now, but how long have you been teaching?
I have been teaching for a total of about 25 years. In this second iteration, I'm reaching the 21st year of being at Suffolk University Law School. I had a stint earlier at another law school, and then I went to the government and back to private practice for a while, and then ultimately returned to law teaching.
Yeah, and I think I've known you for quite a long time, but I think I've always remembered you as a law professor. I may have known you back when you were doing other things, but I always think of you as a law professor. In fact, I was looking at the bio that the university has for you, and it mentions one thing I knew about you was you were president of the Boston Bar Association in 2003 and 2004, and it says that you were the first woman of color and the first law professor to serve in that position. And I'm not sure we've had either a woman of color or a law professor since then in that position.
I think if, the election goes according to plan, you'll have a woman of color. The Boston Bar Association will have a woman of color starting next month or in September. And then I don't think there have been any additional law professors, though. So, and I think one of the other activities that has been very important to me actually for a very long time, but more substantial in recent years, has been being involved in the section of administrative law and regulatory practice of the American Bar Association. And one of the appeals of that section is that the people who are active reflect a good cross-section of, practitioners and academics. And I think that's a really, really great mix so that the practitioners don't get too result-oriented and that the academics, have their ideas tempered by practical reality. So it's a really excellent aspect of participating in that section.
Well, I was Googling you and seeing what I could find out about you that I don't already know. And one thing I learned was that just a few years ago, you became a senior fellow of that section, which I gather from what I read, there are just a small number of senior fellows for a section that has existed a long time. So that was quite an honor.
It is quite an honor. I mean, if you think about some of the people who also have been senior fellows of the section, people like Justice Scalia, Justice Breyer. So it really is nice to be in that company. And then also Boyden Gray, who just recently died, who was a former ambassador to the EU and White House chief of staff. So it's really quite an excellent group of people.
Well, congratulations on that. A few years late, but I know it was well deserved. You've been involved in so many activities, and I encourage anyone who wants to know more to go on the Suffolk Law website and look at your bio, because it's a long, long list of things you have done. Many law-related, some not law-related, all volunteer. What I'm thinking about are all the volunteer organizations. Just to mention a couple of them, you've been presidents of some boards, including the Big Sister Association of Greater Boston, the board of the Shady Hill School, and the Harvard Board of Overseers. And you're a member of other boards. And then for purposes of this conversation we're about to have, I want to highlight a couple. You were, I guess, maybe still are, a member of the Massachusetts Commission on Judicial Conduct?
A former member of that,
okay.
Yes.
and you were also vice chair of that commission. You served on a task force that drafted the revised Massachusetts Code of Judicial Conduct. You, I think, currently are a member of the Committee on Judicial Ethics.
That's correct.
And you are or were a member of some SJC, Massachusetts Supreme Court committees studying gender bias and racial and ethnic bias. So I mention all those because we're going to talk, hopefully at the end of this conversation, about the very controversial issue now about ethics for the United States Supreme Court. And also we're going to talk about at least one or two decisions from the recent term of the Supreme Court that have to do with various forms of bias. So you certainly have a lot of experience in all of those areas. So I guess without further ado, why don't we just start in, Renee? And last year we had the bombshell of the Dobbs decision. It wasn't necessarily a surprise given the makeup of the court. It certainly wasn't a surprise when it was published because an early version of it had, or actually a final or near final version of it had been released prematurely. But that decision overturned 50 years of Supreme Court law, and that had been implemented in a number of ways across many states and federal agencies. And so many people had come to rely on that decision. And it was just all of a sudden declared no longer constitutionally firm. In fact, I guess the majority of the court would say it was infirm from the beginning. Mm-hmm. So that was a watershed moment for this new court that has a 6-3 divide if one looks at the partisan split. Then we were waiting to see what would happen this term, and I think that from my point of view at least, and maybe there's a different point of view, the big decision this year was the students, what is it called? Students for fair admissions.
Students for fair admissions, right.
Versus Harvard and versus the University of North Carolina, which overturned really 70 years of jurisprudence involving integration of schools to do away with or hopefully eliminate eventually discrimination against students of color. So here we are. The Supreme Court has completely rewritten the constitutional doctrines in two areas and also announced a number of other significant decisions this term that cut against what people, I think, had expected the law to be, either statutory law or constitutional law. So with that as kind of a big introduction and a wind-up, why don't I let you throw the pitch? What are your thoughts about what some of the highlights and lowlights of this term have been?
Right.
This past term,
right,
which is now over.
Right. Yeah. So one case from last term that I think is worth mentioning, especially in light of the continued epidemic of gun violence in the country, was the case, the New York Pistol and Rifle Association against Bruin case, where the court basically said that any kind of gun regulation had to be rooted in some historical analogy to the time of the framers. And so, it remains to be seen what the future will be for any effort to regulate the possession of firearms. And the court has granted cert for next term. I know we're going to talk about this term, but for next term, a case, I think from the Fifth Circuit, in which the court decided that based on this historical reasoning, that gun regulations that prevent people who have been charged and who have committed domestic violence, incidents of domestic violence, that those regulations are not lawful anymore. So it will be, it'll be interesting to see whether the court starts to set any kind of parameters on this historical analogy approach. One can recall that, and this is relevant to the Dobbs decision as well, at the time of the founding, women had no rights. It was not unlawful practically anywhere to use force against a woman to whom a person was married, And so I think that the historical analogy might be particularly inept in that context. But then you wanted me to talk about this term. So a couple of things. There were two significant cases involving federal Indian law that the court decided this year. One was about whether the federal government had any kind of obligation to guarantee water rights for tribes on a reservation. The case was Arizona against the Navajo. And the court said no, that even though there's a treaty provision entitling the tribe to rights, there was no affirmative duty to enforce that right. And then the other one that was perhaps more significant, and it's kind of tangentially related to the college admissions cases, is the case where the court upheld the provisions of the Indian Child Welfare Act, which gives Native American tribes the right to control the adoption of Native American children and as a sort of cultural preservation mechanism. And so that had been a very hotly contested issue. Those cases were important in the realms in which they operate, but don't have very super broad impact. So then there was another blockbuster EPA case this term in which the court struck down the Environmental Protection Agency's ability to regulate certain waters that are connected to navigable waters. And this is sort of consistent with the West Virginia against EPA case from the prior term, where the court limited the ability to regulate the air quality throughout the country. So it's, again, kind of saying that the EPA had exceeded its congressional authorizations. And I think that it's sort of a reflective of a deregulatory bent of this court, which we can get into and talking about some other issues as well. And then there were two other cases in addition to the affirmative action cases. Well, actually three. United States v. Texas, in which the court actually said that Texas and other states lacked standing to be able to challenge the Biden administration's immigration enforcement criteria. The Biden administration had set out certain criteria for trying to deal with people who had were present in the country unlawfully. And the argument to the states was that, making these distinctions was not lawful and that the federal government should be trying to round up and deport all illegal immigrants or people who are in the country unlawfully, which is about 11 million people. And so the court, I think, held the Biden administration position for two reasons. One is that immigration arguably deals with kind of foreign policy, national security issues in which the court has traditionally given a lot of deference to the executive and to the federal government as opposed to the states. And then second, because the court has also typically given a lot of deference to the executive's exercise of enforcement authority, and recognizing that its perfect enforcement of any law is not possible, and therefore giving the executive discretion to develop priorities for the exercise of enforcement authority. And then the other big case about presidential power was the recently decided Biden against Nebraska case, which is the student loan debt relief case, in which the courts said that the president did not have the authority to grant limited waivers of the student debt obligations of certain borrowers. And the court in that case relied on its so-called major questions doctrine to say that if a decision by the executive presented a major question that had a tremendous large impact on the economy, then the court was going to say that Congress had to grant more specific authorization for that kind of exercise of executive power. And then the last case I would mention is the 303 Creative case, in which the court ruled that Colorado's public accommodations law that prohibits discrimination, including on the basis of sexual orientation, violated the First Amendment if it were to require a web designer to create wedding websites for same-sex couples when the web designer didn't believe that same-sex marriage was lawful or biblically authorized. And then the very last case, and perhaps this one is the most important one of all, is the Moore against Harper case, in which the court really resoundingly struck down this theory that state legislatures are exempt from any state constitutional constraints in administering federal election law. And this specifically was case involved congressional redistricting. And the court said no, that the federal constitution, in granting the authority to state legislatures, the background assumption was that other state law constraints, as long as they didn't conflict with federal constraints, could still be imposed on the state legislatures. So that was actually a big win for the primacy of judicial supervision, really, of legislatures' activities in regulating, access to voting and representation issues.
Yeah, I would go out on a limb here and characterize that one as, had it gone the other way, it would have been a terrible thing for our country. But the theory behind it was so crazy and unsupported by any historical precedent and contrary to historical precedent, that the likelihood of the court adopting it was probably relatively small.
Right. I would agree.
That was a good description of a number of cases. And obviously it was a very active term. And of course, there are many, many cases that kind of don't grab our interest quite as much, that the court also decided, often on bipartisan grounds. It's not always a divided court. But from the cases you just described, I mean, do you discern any patterns? Where's the court heading? What trends, if any, do you see? Or are these all just isolated instances of courts deciding cases on that case's facts and law, and maybe there's no pattern connecting them?
No, I think there is a pattern connecting them. I think one pattern is with the exception of the immigration case, the failure to defer to the political branches in making some judgments about the impact of regulation on the economy. I think the court also is assuming for itself a role in being the tiebreaker, for policy disagreements between the Congress and the executive. And I think that role is kind of unnecessary for the court to assume. Let's just take the student loan debt relief decision by the Biden administration, for example. If Congress really thought that the president had exceeded his authority under the statutes that Congress has adopted, Congress could always rewrite the laws to make clear that the president doesn't have that authority. The court doesn't need to serve as a tiebreaker in these instances. And I would say the same thing about the environmental protection cases as well, that if Congress wants to reel back this exercise of regulatory power, it can always do it. Now, the problem we have is that we have a really closely divided Congress, so it's very hard for them to reach consensus on anything. But the effect of what the court has been doing, for the most part, is giving this deregulatory bent to policy decisions by the federal government, saying no, the president cannot take certain actions that are arguably authorized by statute.
Yeah, it's really interesting because the way you described the cases, one could look at it and say the court's kind of all over the place, right? I mean, immigration, I think you would think that that there would be justices on the court, and there are some recent appointees who have been criticized for wanting to eliminate the administrative state, right? Or the deep state that some people refer to. And yet it upheld the president's authority to set immigration policy. You explained it very nicely that immigration's different. Immigration is really tantamount to dealing with foreign policy, which has always been the role of the president, the executive. But there's one place where the court's saying, okay, we'll defer to the administration on that. But then when it comes to student loans, we're not going to defer to the administration. Oh, and when it comes to the environment, we're going to allow sort of incremental cutting back on the authority of the regulatory agency. So I don't know. It's to me as a layperson, I mean, I'm a lawyer, but I'm not a law professor or an administrative law professor in particular. But it's a little bit of a patchwork. But I do detect, something of a trend to, I don't want to say weaken the executive, although maybe that is the
No, I
goal.
think that is the goal. I really do
Yeah.
think that is the goal. If you read, what people write who are critics of the exercise of federal power, they sort of take seriously a notion that the federal government was intended to be limited and to only operate within certain constraints. And a lot of things are left to the states. And therefore, we should really tightly constrain federal power. So since 1984, the court decided a case called Chevron against NRDC, National Resources Defense Council, in which it established a rule of interpretation that was as follows: that if there was a statute and an administrative agency was interpreting in a statute through, say, a regulation, and the statute was ambiguous, right? The meaning of the statute was ambiguous after one applied the usual tools of statutory construction, then the court would defer to the reasonable or permissible interpretation of the agency. Well, now we have at least two people on the court who are fully on the record as disliking that rule of construction: Justice Kavanaugh and Justice Gorsuch. Justice Thomas has never liked it. So what then is going to happen if the court decides to back away from that precedent is the court again is going to be kind of second guessing agencies in their interpretations of these statutes. And I would argue Congress gave the duty to interpret these statutes to the agencies, not necessarily to the Supreme Court. And so therefore that is going to have probably a deregulatory bent. And it's really going to constrain the ability of federal agencies to deal with emerging problems. I think there's probably no member of Congress that thinks that Congress is well equipped to deal with a pandemic that suddenly comes upon the country, right? Or to figure out what the relationship is between all these waterways that might have an impact on navigable waters or the aquifers that, we rely on for drinking water in large parts of the country. And so, I think most members of Congress would agree that they are not really well suited to figuring out these questions, which is why we've created the agencies. So I'm actually kind of concerned that this constraint on the agencies is not going to bode well.
And we really see it in Biden versus Nebraska, right? So just so everybody understands what the case was about, Congress had passed a law actually, it was after 9/11, right? Congress had passed a law saying that the president has authority to declare a national emergency, and when it does, remind me.
And when the president does declare that emergency, the president has the ability to waive or modify the terms of student debt obligations.
So along comes the pandemic. The president declares a national emergency. I actually don't remember which president did that, whether it was Trump or Biden declaring a national emergency.
Kagan's dissent in that case says that under two different administrations, there were changes in the administration of the student debt issue.
That's right. Yeah. And then what Biden did was he decided to waive a certain level of student debt, not all student debt. And the Supreme Court majority in Biden versus Nebraska, seemingly influenced by the magnitude of that waiver, because it was many, many billions of dollars and it affected tens of millions of students or past students, that could not have been what Congress intended, is what the court said. And as you mentioned, one of the reasons they gave was this major questions doctrine, which Justice Barrett wrote a whole opinion explaining. So Yeah, a complete lack of deference to the president, although they tried to justify it by saying, well, this is so big that it just can't be what Congress meant for the president to be able to do.
Right. And it sort of reminds me of the part of the decision in the original case challenging the Affordable Care Act, the constitutionality of the Affordable Care Act, because the part of the case that is not talked about as much, but as someone who teaches health law, it kind of, and constitutional law, it kind of emerges more prominently, was the part about the Medicaid expansion that was part of that statute. And, the way the statute was constructed was that if a state failed to adopt the Medicaid expansion, which would cover every person who was below a certain income level previously, that you had, in addition to being poor, you had to be a parent, or you had to have a disability, you had to be aged, you had to have some other status in order to, being poor was not of itself sufficient. And so the court said a state had to accept that expansion provision. And if it did not, then it put at risk all of the federal Medicaid funds that the federal government gives to the states, which is, for every single state in the tens of billions of dollars. Massachusetts is a relatively small state, and it's actually, the Medicaid programs are the single largest component of most state budgets. So the dollars are huge. So the court said, well, even though over the years, Congress, and this was Congress doing it, not just, the agency, that over the years, Congress has changed the terms of the Medicaid program. And, states either have to get in line or with the new terms or risk losing their funds. But this is so massive that, we just cannot allow it. So the court basically rewrote the statute and said that states have the option. And so we're still living in a world, because of that decision, where some 11 or 12 states still have not adopted the Medicaid expansion. Over a period of years, the number keeps dwindling. And the states that have not adopted the Medicaid expansion have some of the poorest health outcomes in the country, poorest health status and health outcomes. So it's really kind of cutting off your nose to spite your face over this ideological point about the Medicaid program. But anyway, so this question about, what is a massive change, and the court sort of policing where the line is I think a very problematic role.
Is that new? I mean, obviously it's not, it goes back at least as far as the Affordable Care Act, maybe, but is that a new thing that the court's doing, or has that always been?
No, I think that's kind of a new thing. I mean, I'm sure one could find, an isolated case here and there, but what it does remind me of are the cases in the run-up to, during the early part of the New Deal and the early part of the 20th century, where the court was taking a very cramped view of federal power under the Commerce Clause, Spending Clause, which is the Medicaid program, and really striking down a great many congressional enactments, saying it far exceeded congressional power. During the early, the Depression and the early days of the Franklin Roosevelt administration, these decisions by the court striking down federal programs that were intended to help people in the economic crisis became very, very unpopular, and led to the court packing idea that Franklin Roosevelt had, which ultimately didn't go anywhere, but it seemed to have the desired effect, which was the Supreme Court started taking a much more deferential approach to congressional judgments about the exercise of power, especially under the Commerce Clause. And starting with the Affordable Care Act case, the court has started to reel that back. Yeah. And so the court is now in the position of setting these limits instead of, having the people decide. Congress is being too generous here, or the executive is being too generous, and not having having the court decide as a matter of constitutional law, I think is very problematic.
So let's talk about what the court is doing in some of these cases. And I'm thinking in particular of Biden versus Nebraska and 303 Creative. Because as you and I know, and I'm assuming anybody listening to this podcast is going to be a lawyer or a law student, because we are kind of talking at that in those terms. But you and I are pretty well versed, you much more so than I am perhaps, in the doctrine of standing. And, we learn in first year of law school that courts are there to decide cases or controversies. So there has to be an actual live dispute that the court, an Article 3 court, is being asked to decide. And if there isn't, then the court says it doesn't have jurisdiction as a matter of what they call justiciability. And we see standing issues in one or two of these cases at least. I'll first ask you about Biden versus Nebraska, but then I also want to ask you about 303 Creative. So in Biden versus Nebraska, the issue of standing was expressly addressed. And the minority there, this, like many of these decisions, was a 6-3 decision. The dissenters said, there's no standing here because the lawsuit is being brought by a state.
By a state which directly has no interest.
Right. It was a separate formed corporation that was there to serve as an agent of the state that would have been deprived of fees if these loans had been forgiven and would have had standing, the minority seems to say, but they weren't a party. The only party was the state. Right.
The analogy for Massachusetts purposes might be Commonwealth of Massachusetts versus the MBTA, right? A separate corporation with its own, revenue streams, debts, that kind of thing. So yes, I think that it was actually, I think, quite persuasive, the argument that the state of Nebraska itself lacks standing. And it was also telling that as the litigation evolved, the state agency that would unquestionably have had standing did not join the case. Justice Kagan's dissent actually says they didn't even file an amicus brief in the matter. And so I think that, either, they were happy with, whatever the arguments were that the state itself was making. But I do think that is a very problematic issue. There was a companion case, too, where two student borrowers who didn't fit into the criteria for getting the debt relief attempted to challenge the executive's decision as well. And the court ruled that they lacked standing. And I think that's perfectly straight up correct interpretation of the law, because no one is entitled to a waiver. Yeah. But under any kind of legal theory.
Yeah, they were saying that if you're going to give a waiver to certain student borrowers, I guess you have to give it to us as well.
Right.
And the argument was, well, nobody has an entitlement to it, so you don't really have standing to make that argument.
Right.
Well, so the court seemed to stretch, perhaps, to take this case and to overturn what perhaps the conservative justices, or some of them, thought was an overreach by the president in eliminating billions of dollars of debt. But then you had the wedding website case, 303 Creative. And I kept reading in the press and hearing people say on television and on podcasts that I listen to that there should have been no standing in that case because, that case was, you described it briefly at the beginning. It was a case where there was a woman who wanted to start a wedding website, and she was worried that if she started it and then was approached by a same-sex couple to have host a website or create a website for them, she would be forced to do it as a matter of the anti-discrimination laws in Colorado, I think it was. And so she wanted the court to rule that her right, as a matter of free speech, I don't even think it was a free religion, even though it was based on her religious views, her right to not have to express a view supportive of same-sex marriage when she created these websites would protect her from enforcement of the anti-discrimination laws. So a lot of commentators said, well, wait a minute, she actually didn't have a website yet. Nobody had asked her to do this. I've heard that there was some perhaps later suggestion of somebody who had asked her to set up a website, and that person has said, no, I'm not in a same-sex marriage. I'm in a heterosexual marriage. I have no idea what you're talking about.
And I've been married for 15 years, something
Yeah.
like that, right?
Yeah. So there didn't seem to be standing in the way we understand standing. There was no dispute. I mean, she would have had standing conventionally if somebody had approached her and she had said no, and then somebody was trying to enforce the anti-discrimination laws against her, and then you go to court.
Right. So I would say that there are two things. First, I think that the facts were correct. And in Justice Sotomayor's dissent, she actually doesn't really deal with the standing issue very directly, and neither does the majority, actually.
Right.
They just kind of
Right.
accept the 10th Circuit's conclusion that there was sufficient controversy here to create standing. But Justice Sotomayor points out that twice, I think, when she starts, the wind up to her discussion of the merits, that the petitioner had never sold any wedding website to the public, not just
Right.
same-sex wedding website, but any wedding website to the public. So it would be a different situation if she had been in the business of making these wedding websites and suddenly she realizes that this Colorado statute could be a problem and she could be subject to enforcement actions if she were to turn away business from a same-sex couple and then come in to try to get a declaratory judgment to insulate her from an enforcement action. And so that would be, in my view, okay to say that she had standing in that situation. So an analogy might be to the abortion providers, right? Or reproductive health care clinics, right? They actually have been in the business of providing these services to members of the public. And then along comes, some state law, back in the pre-Dobbs era that said, oh, you have to have facilities like a hospital in order to stay in business as a clinic. And that obviously was unconstitutional under the Supreme Court precedents at the time. So because they were in the business of continuing to provide these services, they would have standing to challenge the law. They didn't have to wait until the state came after them in some enforcement action. So she's trying to avoid that scenario. But I think you have to be in the business of providing the service in order to be able to create standing.
So why didn't the dissent make an issue out of that? I was just surprised by that because I kept hearing all these things about how there was no standing, and then I read the dissent and there was no discussion of it.
I think the main reason is that, the parties had kind of agreed to let the litigation go forward to get this issue resolved.
Yeah.
And I think the dissent just really wanted to make a big statement about how the majority just got the balance wrong between the First Amendment and the anti-discrimination laws, that you still have your First Amendment rights. She can say whatever she wants to say on her own websites or anything like that, but she can't just turn away a class of customers based on their status that's protected under the state anti-discrimination laws. So I think that the dissenters just didn't really want to have the distraction of people quibbling with them about their standing analysis as opposed to really getting to the heart of the case on the merits.
But it didn't work out so well.
Well, no. I mean, yes, but I think if you read the dissent, it's a pretty powerful recitation of kind of the history of these public accommodations laws and how there just always is this resistance. And there is a film that I like my students to watch in constitutional law. Haven't done it the last couple of years, but I'm bringing it back again, about the Loving v. Virginia case, the case in which the court said that bans on interracial marriage were unconstitutional. And that documentary has real-time contemporaneous footage of people and members of the judiciary saying that interracial marriage is against my religious beliefs. God didn't want it. He put people on different continents, and therefore, interracial marriage is wrong, and states ought to be able to ban it. And sort of religion and the First Amendment have been used since the beginning of time to try to resist the requirement of adhering to the public accommodation laws. And so I think that's really the point that Sotomayor was trying to make.
Okay. Now that you've mentioned the Lovings case, I'm recalling Justice Thomas's concurring opinion in Dobbs. Because as I recall it, and I haven't read it in a while, I think probably since it came out, he was saying, well, now that we've done this, there's a whole other host of other things we should be revisiting. I don't think interracial marriage was one of them, since he is in an interracial marriage. But I think there were others, including the right to contraception. And I'm sure you could come up with a number of others and may recall from his opinion.
Well, there were three that he mentioned specifically. There was Griswold v. Connecticut, which is the right to contraception. There was Obergefell, which is the same-sex marriage case. And then there was Lawrence v. Texas, which struck down criminal laws that banned certain sexual activity among people of the same sex.
Yeah.
And they're all rooted in the same substantive due process doctrine that was the foundation for the right to abortion. And so, I think actually that dissent is kind of scary. It's kind of a shopping list for challengers to come along and to try to undo some of
his concurring opinion.
Yeah, his concurring opinion. I think also, I don't want to be too Pollyanna-ish about it. It's one thing to talk about saying, oh, there's no constitutional right to have contraceptives, which I think would be kind of catastrophic for many people in the country. But it's another thing to say that same-sex marriages are invalid, because what do you do about all the people who have gotten married, who've organized their lives? That one, I think, is a very hard one to unwind in any kind of principled fashion. So maybe that gives me a little hope that, having said what they said on abortion, they'll leave the rest alone for at least for a while.
And just one last question about 303 Creative. I mean, I haven't gone back to reread the wedding cake decision from a couple of years ago. How is this consistent, inconsistent? Are they different? How do you compare those two cases?
I mean, I think they're slightly different. I mean, because, in Masterpiece Cake Shop, you had this full bore enforcement action, right, against the cake maker who had actually refused to make the wedding cake for the same-sex couple. Yeah. And the other overlaying issue in Masterpiece Cake Shop was that the Supreme Court sent it back to the states because it was concerned about certain comments that people on the Colorado discrimination, Commission Against Discrimination had made during the context of the enforcement action, saying that they reflected bias and animus against the cake maker and the cake maker's positions. So that kind of, you're sort of not clear in some ways where that all kind of leaves you with respect to some of these issues. So just because they were decided on such different bases, I think it's hard to compare them. Although I do think the common thread is, which relates to a whole bunch of other cases, which the court didn't really have so many of them this year. They give a lot of credence and deference to people's statements that it would be against my religion to have to comply with this law. And, I think that's a problematic trend.
Yeah. So I want to talk about one more case and then briefly talk about ethics. So the other case, you can guess, it's Students for Fair Admissions versus Harvard and University of North Carolina, two separate cases, but raising the same issue, really. So just again, for people who aren't terribly familiar with it, this is the decision in which the new supermajority on the court, this used to be the Roberts Court, I'm not sure it is anymore, although he wrote this opinion. The new supermajority on the court said, well, it's time to end affirmative action for college and university admissions. And while it was acceptable in the past for race to be a factor, and there are some precedents in the Supreme Court for that race can be a factor in a holistic admissions determination, it no longer can be. It's time to put an end to that. And the 14th Amendment doesn't protect the right of minority students to have race considered as a factor in trying to really overcome a history of discrimination that the dissenting opinions very eloquently argue is still real. I take this one a little bit personally. I'm not a member of a minority, but until a week or so ago, I was on the board of trustees of a liberal arts college. I chaired the board for a few years, and we were very proud of our DEI accomplishments, diversity, equity, and inclusion, and we've done a lot in that regard, as have so many colleges and universities. And all of a sudden now, this decision comes along and says, well, you can't consider race as a factor in admissions anymore. And then everybody immediately starts asking the questions, well, what else does it mean? It's first of all, what do we do with our admissions policy now? And the Roberts Court kind of leaves a little narrow space open for consideration of race.
If the student brings it up, right? Yes.
In their essay.
Right.
Yeah, they have to write in the essay how their race has affected them personally. So it's basically a disavowal of the notion that there's structural racism in our society, which is really unfortunate because, as the dissent, one of the dissents says, I think it's Justice Jackson's dissent, your reasoning and reality are totally disconnected, because the reality is that racism still exists and it's very prevalent, and the only way to counteract it is to be conscious of race and to take it into account. Justice Roberts has always been of the view that you have to have a colorblind society. The problem is society isn't colorblind. Colleges go back and now they have to figure out how do we change our admissions policies? Hopefully they've been thinking about that for the past year because everybody thought this might be coming. But then people are starting to ask the questions, well, what else does this affect? How does it affect a college's DEI programming? How does this affect the job market outside of colleges? How does this affect affirmative action in hiring for a private company or a public organization? Everybody's asking those questions. And my first take on that, and I'm sticking to it as long as I can, is no, it's a narrow decision. It affects college admissions only. The court wasn't asked to address those other questions. And so whatever you thought you needed to do to create racial balance and to create diverse talent in your company, on your board, in your student body, whatever else you need, or at least outside of considering race as a factor in your student admissions, keep doing. The court hasn't said you can't, but I know that's probably a simplistic
So
answer.
I would say I would take a step back a little bit. So first of all, just to address your point about whether you can have a remedy for the history of race discrimination in this country and for the continued embedded structural racism, I would commend listeners to a piece a guest essay, I guess they call them now, in the New York Times that Professor Randall Kennedy at Harvard published early in June, about a month ago, called "The Truth Is Many Americans Just Don't Want Black People to Get Ahead." And it goes through all of the remedial efforts post-Civil War that have been stymied either by presidential veto, the Supreme Court saying that the first public accommodations law that Congress tried to pass in the late 1800s was unconstitutional, and then going through all of the resistance to various other forms to try to, really, make good on the promise of the United States that everybody will be treated equally. And so I think it gives you a really good survey of the history there. Second, I think that for a long time, and I'm going to disagree with you with a little bit of what you said, for a long time, it actually has not been lawful to use race as a criterion in hiring or promotions or in deciding who gets laid off or not under the ruling precedent. And which brings me, and the reason for that is because of the existence of Title VII, which is the statute that prohibits discrimination on the basis of, a whole variety of categories: sex, race, religion. But the interesting thing about the Harvard and UNC cases on these college admissions is they didn't talk about the comparable statute that would apply to universities, which is Title VI of the Civil Rights Act for organizations that receive federal financial assistance, the statute calls, or, federal funds. And sort of cast the entire decision in constitutional terms. even though arguably that doesn't really apply to Harvard, right? UNC, because it's a public university, maybe not Harvard. But they were obviously, wanting to make, kind of big statement about this. But to answer the impact question that you have, I would say it is going to have a big impact, because these decisions do is affects the pipeline of people coming out of the institutions from which, employers, recruit their employees, or they consider their qualifications, what have you. And so I think that's going to be a problem. The history of these things is, we have some natural experiments that we can look to, because several states have prohibited the use of race in college admissions for a number of years: California, Michigan, a number of them. And I think it's a total of 9 or 12 states. I forget the number exactly. And what almost always happens is the number and the percentage of Black students and Hispanic students declines because of the inability to use race. Now, right. And so, the question people always say is, well, what about the impact on people who would have gotten in but for the use of race? Well, I think that's a really hard but for to prove. Okay, so for example, if I look back, I did some looking back at the Bakke case, which is where this all started, which was the person who applied to medical school at UC Davis and didn't get in. And then one of the Michigan cases, the Grutter case, the Michigan Law School case. I think those cases are as much about age discrimination as they are about race discrimination. Bakke was, I think, 38 years old when he applied to medical school, and Gratz was 43. She had this other career, she, had children, all this stuff, and she decides she goes to go to law school. But you can't, age discrimination is a really harder claim to bring. And so lawyers look around for what else can I use to try to say that I should have gotten in? Well, race is the but for, right? So that's one thing. I think that a lot of this, the court makes this mistake, I think, in the Harvard and the UNC case decision, in that it talks about it as if race was this overriding, overwhelming, determinative impact on the majority of admissions decisions. It's just not true. You know this from having been a college student, right? It only operates at the margins. I would say if it was having that kind of determinative effect that the court seems to ascribe it in this case, the statistics should be a lot better than they are. And they're just not. The representation of Blacks and Hispanics at all of these elite universities is far below the representation in the population. I guess I'll say one last thing, and then if you have other questions. The other issue is that the recent cases have been cast as the use of race operates to the disadvantage of Asian American applicants. And so, won't get into all the, factual weeds of, what discovery showed in some of these cases. But the bottom line is that, and the court has one very disturbing sentence in the Harvard and North Carolina cases, which is, well, of course it had a detrimental impact because the numbers of Asian Americans will decline. Right, will decline as soon as you start admitting more Black or Hispanic applicants. Well, I don't know where that leaves us, right? Because there are a finite number of places at all of these schools, and if you let in more football players, possibly you're going to let in fewer musicians and vice versa, right? So I don't know where it cannot be the rule that just because the numbers change over time, that there's discrimination going on. So I just think there's still remains a lot to be sorted out by these things. But I think that employment is, that I think that I think it's not going to have a good effect.
Yeah. And I would add this. As somebody who's been very aware of what colleges are doing in their admissions policies by trying to have diverse classes, they're doing it for all the reasons that Harvard explained it was doing it, which is to create an environment where students can learn from a variety of perspectives just from among the people around them. Be exposed to different viewpoints, be exposed to different experiences, be exposed to different backgrounds. You get that when you have a diverse student body. You lose some of that as you lose diversity, and that affects the quality of the educational experience.
Right. Can I just say one other thing? I gave a talk a few weeks ago to a conference of health law professors, and it was about the potential impact of this decision on the healthcare workforce, specifically the physician workforce. So today in the United States, according to the brief filed by the Association of American Medical Colleges, which represents all the medical schools, and it represents a whole bunch. The brief was filed on behalf of a bunch of other organizations as well. There are fewer Black male physicians practicing in the United States today than there were in 1978 when Bakke was decided. All right, so that's a really frightening statistic. And since Bakke, there have been studies that have shown that the diversity of the physician workforce is actually essential to trying to address healthcare disparities based on race.
Because the patient population is diverse.
And the Black, Hispanic patient populations have an understandable suspicion of the healthcare enterprise because of various bad stuff that we don't need to revisit here, but that has happened, historically. And so having a face that they can trust as they, consider healthcare treatments or even consider whether to go to the doctor at all or not is just a really important thing. So I think that there actually is a great deal of concern about those issues as well.
Well, this is another place where I know Chief Justice Roberts would disagree with this characterization, but it seems like the Constitution meant one thing when you had a different composition on the court. And now that you've got this composition on the court, the Constitution means something very different. He would say, well, 25 years ago, we said that we would eventually have to, eliminate the consideration of race in college admissions. And the dissent very ably says, yeah, but things haven't changed that much. Race is still very much a problem. Racial discrimination is still very much a problem. And you can't pretend that all of a sudden things are better because they're not. So
I know what Justice Jackson said, just because the court is saying it doesn't make it so.
Yeah, her opinion is so powerful, and so is Justice Sotomayor's opinion. I hope if anybody is reading the majority decision in this case, they're reading those two dissents as well. I just want to cover one more topic with you, and that is maybe two, but one intellectual topic and one more personal. The first topic is ethics on the Supreme Court. You are an expert. You may, whether you call yourself that or not, you're an expert on judicial ethics. And we're at a point where I think the approval rating of this court is at an historic low. I think it's got about a 20% approval rating, if I'm remembering correctly, among the American public, which is terrible. And because of the nature of the institution, it depends on public approval for its legitimacy. We've had real controversy in how appointments have been held up and made in the past few years, which also creates a lot of doubt about the legitimacy of this court. I'm not going to question the legitimacy of this court. I don't want to get into that conversation. But in terms of public perception, it's a real problem. And I am concerned about all the things I've been reading and hearing about ethical issues affecting the justices, and in particular, 2 or 3 of the justices. So I know there's an effort to try to get Congress to act on this and do what I think it is authorized to do, which is impose binding ethical requirements on Supreme Court justices. Maybe there's not agreement on whether they have the power to do that because of the separation of powers doctrine. But let me just ask you about that, Renee. Where do you think we are, and what do you think can be done about it?
Well, I do think that the Congress has the authority to do it. I mean, the court has already agreed to file substantial financial disclosure requirements. There's a federal statute that sets out the terms of mandatory recusal if the judge or a close family member has a financial interest in the outcome of a case. And, presumably the justices are adhering to those statutory requirements, although we still don't have the latest financial disclosures from two of them, who seem to be the most problematic. I think they have a lot of mending to do of past reports, which is why their current report is late. So I don't think that there's a separation of powers issue, because the Congress would not be telling the court how to decide their cases. That would be a problem from separation of powers point of view. I agree. They're just saying, if you're going to sit and decide a case, then you have to adhere to these transparency requirements that every other federal judge and every other state judge in the country actually has to adhere to. I mean, there might be some slight differences in the rules, but the general tenor is the same. I noticed that in the Harvard and UNC case decision, Chief Justice Roberts takes this swipe at the two universities by saying, you're just basically asking us, they're saying, trust us about our use of race in this. Well, the court is asking the public to trust them about their adherence to reasonable ethical principles. Right. And if it doesn't work for Harvard and UNC, certainly does not work for them, who are public officials and who make decisions that affect, the lives of everyone in the country.
So you and I are both active in the American Bar Association, and we're at the last House of Delegates meeting, I think. Another one coming up soon. What is the American Bar Association saying and doing about this?
So at the last meeting, as you know, the I forget which section proposed this resolution, but there was a resolution that the House of Delegates voted to approve that urged the Supreme Court itself to adopt a public and binding code of ethics. And then that was part one of the resolution. And part two was urging other bar associations around the country to adopt similar resolution.
And in fact, our association, the Boston Bar Association, has done that.
Exactly.
And I think the Massachusetts Bar Association probably has as well.
Right. So, I don't know how many, and actually now I do remember, now that we're talking about this, who the proponent of that resolution was at the ABA. It was actually a King County Bar Association from the state of Washington. So I think the organized bar does have a role to play in trying to shore up the legitimacy of the court. I mean, some of the justices, Justice Roberts, Chief Justice Roberts, Justice Thomas, they complain that, lawyers aren't coming to their defense. Well, it's hard to defend the indefensible. And and they are in the best position to really make all the criticism, not all of it, because everybody's still going to disagree with some of their decisions, but to make the criticism about these ethical rules go away by adopting a code that is very consistent with the code that applies to all the other federal judges.
Do you think it'll happen in our lifetime?
I don't know. I mean, I think, perhaps there does seem to be some bipartisan support for it in the Congress. So if the judges really thought that Congress was going to pass a law, they might actually try to get ahead of it and do it themselves.
Yeah. So on the personal level, and not really personal, more professional, you've been teaching law students for 25 years, I think you said. What can legal educators do to inspire their students to be vigilant in protecting our constitutional democracy as lawyers?
So what I always say to students is that the legal education empowers them to be super involved and attentive citizens. And that they shouldn't just sort of get their degree, pass the bar, and then just go around start making money, right? Which, I know everyone needs to do, but really to stay engaged at some level on some of these issues that affect the evolution of the law and, at whatever level, state, local, federal level. So for a long time, the very first time I taught constitutional law, which was probably about around the year 1990, 1991, something like that, I had assigned The Handmaid's Tale for students to read in class and to write a paper about.
You were ahead of your time.
And, I always hoped that it would be this kind of like deterrent message, right? This is what happens if you get too complacent about your rights. And now I sort of feel that that's, as important as it ever was to sort of get students to see that they can make a difference in these outcomes. The other thing I do in class is when we talk about the big cases, I always, have little pictures on my slides of the lawyers, the judges, all these people. And for some of these cases, the lawyers were very young when they litigated these landmark cases. Yeah. Sarah Weddington was 26 years old when she argued Roe v. Wade. Thurgood Marshall and the other lawyers at the Legal Defense Fund were really quite young, in their late 20s, 30s when they argued some of these landmark cases. And for Loving v. Virginia, the case came through the ACLU. The ACLU found lawyers to represent the Lovings in that challenge to these Virginia laws. They were young. One of them was only 3 years out of law school. One of them, I think, wasn't even a member of the bar. There had to be special. He actually didn't qualify for admission to the Supreme Court bar when the case came before the court because he hadn't been a lawyer long enough. And so I say to them, just because you're young doesn't mean you can't make a big difference in the evolution of the law.
Good.
Yeah.
Is there, where can people turn to learn more? Is there a book you would recommend, a movie, anything that after this podcast, if people want to learn more about the Supreme Court or judicial ethics or any of the issues we've been talking about, what would you recommend today?
So I already mentioned Randy Kennedy's article about and it's very, it's a New York Times guest essay, so it's not that long. The other book that in addition to The Handmaid's Tale, I think it's worth a read. Dystopia becomes somewhat reality. I think also reading Richard Rothstein's The Color of Law. You mentioned the Boston Bar Association. He was the speaker at the Boston Bar Association annual meeting a few years ago, right after the book was published, which really gives examples of how structural racism has been embedded in government policies that have affected, the financial stability of families around the country to the disadvantage, particularly of Black Americans. So if you have any doubt about the existence of structural racism, I think that book should dispel any of those doubts. And then there's another book that I used to assign, and I'm thinking about it. I'm not teaching con law until the spring, so I have some time to kind of think this through, called Praying for Sheetrock by Melissa Fay Green. And it's about a community in Mississippi that, in the opening chapter, she talks about how the civil rights movement had kind of passed it by. And, we catch up to them in the 70s. And it, really talks about how changes in, whether the county commission, for example, is an at-large elected commission or if there are districts, how sort of changes like that can make really big impacts in the ability of previously excluded groups to gain representation. But then there's also a disparate law enforcement component to it as well that I think is actually spoiler alert, a little kind of tragic story, but it's really very moving and I think worth a read. And then I already mentioned I think it's called The Loving Story, this HBO film about the Loving against Virginia case, which is a really good case. I'm not here promoting HBO, but I'm just saying that, and if you need a way to get it free without having to subscribe to HBO, I can tell you that too offline. So.
Okay.
I'm not going to ask you about that. No, my law library
Okay.
found it. You just have to sit through some ads. So it's okay.
Okay. Well, Renee, this was really delightful and very informative. So thank you very much for your time. And I look forward to seeing you at the ABA annual meeting in Denver in a few weeks, along with some of our other colleagues.
So thank you, Don, for a great conversation and for inviting me to join you today. And thanks for your most excellent preparation for all of this. This has been wonderful.
Thank you. Take care.
Bye-bye.
This has been an episode of Higher Callings. Your host is Donald Federico. Music is provided by Fancy Mountain, and our logo was designed by Matt Boudreau. The associate producer is Brian Federico. Higher Callings is a production of Federico Media, LLC.